Good afternoon, distinguished guests, professor, college, and students. Welcome to International Public Lecture under the theme of Executive Power and Erosion of Academic Autonomy, American and Indonesian Experience. My name is Zita Mutiara Salim, as your Master of Ceremony for today's agenda. It's such an honor to greet and to see so many beautiful faces this afternoon. I would also like to welcome our distinguished guest from Indonesia Jentera School of Law and University of Washington School of Law. Welcome to Bandung. Ladies and gentlemen, this event is a collaboration between Indonesia Jentera School of Law, the University of Washington School of Law, and the Faculty of Law Universitas Pajajaran. Today, we gather not only to exchange scholarly insight, but also to strengthen our academic collaboration across institutions. Before we begin into the main session, we will have a series of welcoming remarks and also an MOU signing ceremony. Moving into our first agenda, which is singing Indonesian national anthem, Indonesia Raya. We kindly ask for all of the participants to please stand up. Ladies and gentlemen, you may now be seated. To officially start our agenda today, I am pleased to first invite Dr. Sigit Suseno, Dean of the Faculty of Law, Universitas Pajajaran, to deliver his welcome remarks. Please welcome Dr. Sigit Suseno.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Yang saya hormati, izinkan saya pakai bahasa Indonesia. Nanti ini semua Pak Dekan dari Jentera. Hukum di Jentera Suroto. Jadi jajarannya ya 13 sampai 15 ya. Yang saya hormati para pembicara, Profesor Elizabeth Porter, welcome to campus Faculty of Law Universitas Pajajaran at uh, Jalan Banda, Bandung, and Professor Mirai Butler. I hope my pronunciation is correct because it is French. Yang saya hormati Prof. Susi, saya kira baik dari Jentera maupun dari Unpad sudah sangat mengenal Prof. Susi. Prof. Arif, kemudian manajer riset Ibu Nela, Ketua PSKN, para dosen dan mahasiswa. Pertama-tama saya mengucapkan selamat datang di kampus Jalan Banda. Welcome to kampus Jalan Banda Bandung. We have three campus. The first at Jatinangor, the main campus, and second is campus, and third in kampus di Pati Ukur. Mungkin kalau dari Unpad sudah pada tahu ya. Kalau kampus di Jatinangor itu untuk undergraduate, untuk kampus Jalan Banda ini untuk graduate program, untuk master dan doktor. Mudah-mudahan kegiatan lain kali kita bisa di Jatinangor, Pak. Kita bisa mendapatkan suasana yang lebih fresh, because we have many trees in Jatinangor. Pertama-tama saya ingin menyampaikan ucapan terima kasih yang tidak terhingga untuk Jentera Law School dan University of Washington School of Law atas kolaborasi untuk bisa menyelenggarakan international lecture dengan topik Executive Power and the Erosion of Academic Autonomy, American and Indonesian Experience. Yang tentunya ini akan sangat berharga untuk mahasiswa kami, bisa menambah wawasan dan perspektif keilmuan, dan mudah-mudahan ini bisa menambah ilmu yang sudah saudara dapat. Ya. Ingin saya sampaikan bahwa international lecture ini dihadiri oleh khususnya yang mahasiswa yang graduate program, yang master dan doktor, dan juga dari kelas international undergraduate program. Kebetulan Unpad sudah tahun ketiga ini memiliki kelas internasional, dan tahun ini sudah mulai kegiatan international exposure. Jadi kita punya juga beberapa kerjasama dengan Melbourne Uni untuk student exchange, kemudian dengan UiTM di Malaysia, kemudian UTS, dan ke depan kita mencoba untuk dengan Shanghai University dan beberapa universitas di Thailand, ya, Chulalongkorn sama Thammasat, ya, Thammasat University. Mudah-mudahan kita akan lebih banyak kolaborasi. Jadi kegiatan international lecture ini juga kami harapkan ini awal untuk kita bisa menjalin kolaborasi dan kerjasama yang lebih luas, bukan hanya aspek seperti lecture sini, mudah-mudahan bisa juga kita kerjasama untuk bidang lain, ya, bidang lain seperti riset atau berbagai kegiatan yang bisa meningkatkan masing-masing baik dari Fakultas Hukum Unpad maupun Jentera untuk meningkatkan reputasi akademiknya dan memberikan yang terbaik untuk mahasiswa kita. Sebetulnya kalau Unpad ini bisa disebut terlalu besar karena dari sisi student body mungkin sampai kalau semuanya 3.000, Pak. Seluruh mahasiswa seluruh angkatan ya, mencapai 3.000. Jadi untuk yang angkatan terakhir ini 508 mahasiswa. Jadi sebetulnya kalau kita lihat berbagai kesempatan untuk kita meningkatkan reputasi, sebetulnya banyak. Hanya kita seringkali dibebani oleh beban-beban yang tidak penting ya. Aspek administratif sehingga kita tidak bisa mengoptimalkan potensi yang ada untuk membangun reputasi akademik sebetulnya. Jadi kita sering terjebak di aspek administratif. Sekali lagi mudah-mudahan kolaborasi dengan Jentera kita bisa meningkatkan reputasi akademik baik di bidang pembelajaran maupun di bidang riset. Terakhir saya sampaikan terima kasih untuk dekan, Pak Dekan dari Jentera, kemudian Profesor Elizabeth, Profesor Mireille, for graciously visiting to the Faculty of Law to share your knowledge for my student. Saya kira itu sambutan dari saya, mudah-mudahan apa yang kita lakukan menjadi bagian dari amal baik yang bisa kita berikan untuk mahasiswa kita. Saya akhiri, selamat berdiskusi, ya mudah-mudahan kita bisa melaksanakan kegiatan ini dengan baik dan lancar. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Dr. Sigit Suseno, for your thoughtful remarks. Moving into the next session, I would like to invite Dr. Arya Suyudi, SHLLM, Chair of Indonesia Jentera School of Law, to also share his welcome remarks. Please welcome Dr. Arya Suyudi.
Pak Dekan, mohon izin saya pakai bahasa Inggris saja ya. Karena saya tadi Pak Dekan bilang banyak mahasiswa IUP di sini. Berarti sudah pas pakai bahasa Inggris dan tidak perlu penerjemah. Baik, Honorable Dean Dr. Sigit Suseno, SHM Hum, Dean of School of Law, University of Pajajaran, Honorable Profesor Susi Dwi Haryanti, Professor of Law, University of Pajajaran, Bapak Arif Surwijoyo, Founder and Chair Indonesia Jentera School of Law, 2020-2024, distinguished guests, colleagues, students from Unpad and also from outside Unpad, Assalamualaikum warahmatullahi wabarakatuh. And also, I forgot, colleagues from Jentera, because we are 15 of us from Jentera coming here. Welcome. It is a great privilege for me to stand before you today as we open this important international lecture, which titled Executive Power and the Erosion of Academic Autonomy, American and Indonesian Experience. This event is a testament to the strong collaborative spirits among our institutions, University Pajajaran Faculty of Law, the University of Washington School of Law, and Indonesia Jentera School of Law. I extend a warm welcome to our esteemed speakers, Professor Elizabeth Porter and Professor Mireille Butler. I hope I spell it correctly. Mireille. And also Professor Susi Dwi Haryanti from the Faculty of Law, University of Pajajaran. Your expertise and insights are invaluable as we tackle a fundamental question of our time. Can academic autonomy survive in the face of increasing executive power? The theme of today's discussion is incredibly timely. We are witnessing a global trend of executive branches consolidating power, a phenomenon that poses direct challenge to the traditional safeguard of democracy, including the independence of academic institutions. This is particularly true in the US, which is our resource person will share a lot of story about this. And if you monitor the media, there has been so many news telling the story, the tension between the executive branch of government in US in dealing with universities, which is very concerning for future of independence of autonomy of the university. The question is now no longer hypothetical. It is a critical inquiry to whether academic freedom remains a protected space for critical thought and research, or if it is being slowly but surely eroded by political intervention. Today, we will engage in a cross-national discussion that bridges the American and Indonesian experiences by examining these two distinct contexts. We can gain a deeper understanding of the common challenges of and unique dynamic at play. This dialogue is crucial because the integrity of our academic institutions is directly tied to the health of our democracies. Universities are not just places for learning. They are vital spaces for dissent, innovation, and independent inquiry. When that space is compromised, the entire democratic project is at risk. On behalf of Indonesia Jentera School of Law, I would like to thank University of Pajajaran and University of Washington for this partnership in this making event a reality. This collaboration underscored our shared commitment to academic freedom and fostering critical legal discourses. Jentera truly wish that in the future, more collaborative events like this can be organized to further advance the quality of legal discourse and quality of legal education in Indonesia. I am confident that today's lecture will be insightful, thought-provoking, and a significant contribution to this crucial conversation. And also, I would like to also echoing to what Dean Sigit just mentioning, it is indeed that international cooperation is very crucial for the future of our legal education, because like us in Jentera, we are a small university. We just established in 14 years ago. And we see that strategic collaborative effort with as many as possible stakeholder, including national and international stakeholder, is crucial. Jentera have ongoing cooperation with Melbourne University, Leiden University, Australia National University, and we also hope that in the future we can also establish further strong relationship with national university like University of Pajajaran and other university. I'm confident that thank you for being here, and I look forward for enriching discussion. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Arya Suyudi, for your valuable insight and warm words. Ladies and gentlemen, we will now proceed to the signing of MOU between Indonesia Jentera School of Law and the Faculty of Law Universitas Pajajaran. I kindly invite the representative of both institutions to the front for this short signing ceremony. Next, there will be now a presentation. Okay. Next, there will be now a presentation. I kindly please hold on into the position, because there will be a presentation of plaques given by each institution as a symbol to mark our excellent beginning for development of broader academic partnership in the years ahead. And I also would like to kindly invite our distinguished guests from both institutions, from Jentera School of Law and Universitas Pajajaran, to join us here for the documentation session. The Memorandum of Understanding signed today reflects the commitment of both institutions to foster academic collaboration. Hopefully, this MOU will build a strong foundation for the future cooperation between all the institutions involved. Once again, huge congratulations to both of the institutions, and please give them a warm round of applause. Before we begin into our main part of today's agenda, which is the panel discussion, we would like to have a documentation session first between all of the participation and all of our distinguished guests. Let's see document. I would like to ask for all of the participation to stand up. Okay. Satu, dua, tiga. Sekali lagi, satu, dua, tiga. Okay. Now we're moving forward to the main part of today's agenda, which is the panel discussion. It is my pleasure to introduce our moderator for today, Pak Bilal Dewansyah SHMH. Pak Bilal is a PhD student at Leiden University, as well as respected scholar and lecturer at the Faculty of Law Universitas Pajajaran, who will guide us through the discussion with our distinguished panelists from University of Washington, as well as Universitas Pajajaran. Without any further ado, I now hand the session over to our moderator. Pak Bilal, the floor is yours.
Good afternoon, everyone. Welcome to the Faculty of Law, Pajajaran University. Also, welcome to this international lecture. We are now would like to discuss the topic. I think these very important topics about the executive powers and the erosions of the academic autonomy comparison between the US and Indonesia's experience. So as maybe Dean Aryasudi said, it's also relates to how the governments, especially in the US, but I think not only in the US, but this is also relates to global spreading of the populist political movement around the world, where the populist government now take the power. And also in the US, we are witnessing how the Trump administrations also use the executive power to control everything, but also in this case, also to control higher education, the university. And then how it also use the executive, I think, instruments like executive order to control this. And we also maybe experiences almost similar things in Indonesia, since two populist governments in office since the President Joko Widodo and now currently President Prabowo. And then some symptoms we already experienced in the university, not only how the student in many university has been silenced by the governments, and also how the government also try to control the university from a lot of things, including the budget. So we have an important questions on this. To what extent the executive powers, which is also in the US and Indonesia, elected by the people, can be also control the higher educations? Is it justified to control our university government that require strong academic freedom, by which, you know, the instrument that a lot outside the parliamentary control? So to address these questions, we have three distinguished speakers, two professors from University of Washington, Seattle, and one professor from the University of Pajajaran. I would like first to introduce them. So first of all, this Professor Mirela Butler is a professor of the University of Washington School of Law. I do a little research on you. So Professor Butler is a teaching professor at the University of Washington Law School, and she is also a co-director for legal analysis, research, and writing courses. She has some degrees in law from the University of Bordeaux, France, and then also JD from the Washington University School of Law at St. Louis. Applause for Professor Butler. And then the second speaker is Professor Elizabeth G. Porter. So Professor Porter is also a university professor, professor of the University of Washington, etc. She is a James V. Mifflin University professor at the university, and also a co-director for the appellate advocacy clinics. So these two professors are expert in American legal system, and we'll talk about American experience on this topic. The last but not least speaker, we have our Professor Susi Dwi Haryanti, SH, LLM, PhD. She is head of Constitutional Department in our faculty, and she holds some degree in law. She graduated from the University of Pajajaran Law School, and then she continued her educations in Melbourne Law School, and then obtained her LLM and hold PhD from that university. So Bu Susi will share Indonesian experience on this topic. So without further ado, I invite the three speakers to come in front with us to start discussion, please. Yeah. So to honor our guest speaker, of course, the first opportunity, I would like to give to Professor Butler and Professor Mirella, Professor Porter, to start the presentations.
Dr. Arya Suyudi and Arif, thank you so much for giving us this opportunity as well. We would like to start with this presentation on executive power and higher education in the United States. We have already done wonderful presentations. Do I just click here or here maybe to move? There we go. We can pass on the next slide to move to the heart. We have already done this. So you have gone introductions from everyone. There we go. And we can actually start with the substance of what we are dealing with. And I'll cede the floor to my colleague, Professor Porter.
As I'm sure you know, we have a long tradition of academic freedom at institutions of higher education in our country. And that academic freedom, combined with a deep and equally important tradition of governmental support, has helped make American institutions of higher education some of the best educational institutions in the world, fueling innovation, activism, public health, and many other important policy objectives. In his second term as president, however, President Donald Trump has targeted higher education, both in terms of specific institutions and as a category of educational institutions as a whole, in an ongoing series of executive orders. As of now, several months into this Trump administration, it's actually unclear whether courts will ultimately find that these orders are constitutional in part or in whole. Unfortunately, however, already significant damage has been done. So today we'd like to talk a bit about the law of presidential power, the legality or non-legality of some of these executive orders, but we'd also like to recognize that we're in a situation where law alone cannot provide answers to these questions, and that sometimes even legal actions that are found later to be unlawful may nevertheless have already caused significant damage.
So we have decided we could actually spend a lot of time just focusing on all of the issues that are happening in the United States right now, but we have decided to try to narrow down this discussion a little bit more into three types of general areas. And the first thing that we wanted to talk about is Professor Porter will set the scene a little bit in terms of what is the kind of presidential power in the United States, how has it been used, and how is it being used now? How is President Trump actually using this right now? And then we will be more specific about the very kinds of targeted actions that have been taking place against institutions of higher education in the United States.
This is Article 2, or a summary of Article 2 from our Constitution. As you, again, probably are aware, the United States Constitution is one of specific and limited enumerated powers. The federal government does not have powers except those powers that the people specifically gave to it in the Constitution. So here are some of the key powers that the president has under Article 2 of the Constitution. And you'll notice that in our Constitution, president, the executive branch, is the second in line. Article 1 of our Constitution is to Congress, right? Keeping in tune with ultimately our respect for allowing people to democratically choose not only their leaders, but the trajectory of their country. So the president serves as commander-in-chief of the armed forces. The president is endowed with the power to pardon people from federal offenses. I think this is in fact the only power. The pardon power may be the only power that is exclusively belongs to the president and is not shared with other branches. The president also has the ability to appoint officers and judges and justices, which is an important factor here because of the President Trump's recent appointments to the United States Supreme Court. The power to enter treaties, the power to recommend laws to Congress, which I believe seems like a fairly boring power, but which has been incredibly important and powerful under President Trump, who, for example, named the most recent annual budget bill the big, beautiful bill. And now everybody in the country, even people who detest the bill, call it the big, beautiful bill. Above all things, he is good at marketing. And finally, the president must execute and implement the laws passed by Congress and approved by the Supreme Court. One of the ways that the president can take actions are through executive orders. Historically, and up until recently, executive orders have been very important and generally very boring. They have been dull, technocratic instructions from the president to other agency executive branch officials, instructing them to take certain actions. They generally sound like legal documents and accomplish fairly technocratic legal goals. Do they have the force of law? Does an executive order by President Trump have the force of law? The answer is, it depends. An executive order, merely by calling itself an executive order, is not endowed with a particular legal protection. So executive orders that are valid exercises of President Trump's powers can have the force of law. Conversely, executive powers that extend beyond the president's powers are not legal or valid and can be dismissed by courts. Importantly, in this administration, differently from how it's been done in past administrations, President Trump is also using executive orders as powerful tools of communication. not only communication to members of his government, but communication to Americans, communications to the world, communications to his base. If you read his executive orders, which you can do because they're all, of course, available, many of them sound like social media posts. And that is intentional. So these executive orders are different than what we have encountered previously.
And you will see even in the title of some of the executive orders that we will show you later on, you will see that some of them have actually very interesting names. Now, I'm not sure why when I'm clicking, it is not going through again. And some of them are actually very funny. And I think that we all have a little bit underestimated the political genius of someone like President Trump, because he actually has been incredibly intelligent at marketing. So the first kind of executive order, Liz.
We wanted to show you a few other important executive orders in history, which I think provide an important counterpoint to the current culture of executive orders. This is one of the most famous documents of American history. It's the Emancipation Proclamation, where President Lincoln, during the Civil War, declared that all the people that had been enslaved by the Southern states and the Southern breakaway government were freed. So it's actually called a proclamation because we didn't have the term executive order till a bit later. And we still sometimes call things proclamations. The distinction is not significant. So this document is part of the essential DNA of our history, and it represents a hope of freedom and equality.
Another kind of executive order that you may also have heard about is President Truman's executive order on desegregating the military. There was an African-American man who had served during a Second World War, and he came back to the United States in a state in the South, and he was viciously attacked, actually left permanently maimed after that. And President Truman thought, this is just a horrible thing. We cannot do this. So he issued that kind of executive order. Again, very much, as you can see, something that really protects people's individual freedom, not at all a tool of restriction, but a tool of protection. In that same vein, President Obama, you may also have heard about this order, created DACA. And DACA was applicable to children who came to the United States as immigrants without any papers. This doesn't allow them to actually have a path to citizenship, but it allows those children who now are adults to get work permit and to get protection against deportation. President Trump's use of executive orders is a little bit different, as we will go into a little bit more depth. What is really quite striking, at least as a procedural matter, is that President Trump signed almost 40 executive orders on his first day of office, 142 in his first 100 days. So he is really governing to a certain extent by fiat, instead of governing with Congress, governing in a traditional way that presidents have governed before.
When determining whether or not these executive orders are lawful, we need to look at the constitutional framework for analyzing executive power. And in our country, that constitutional framework comes from a decision from the 1950s called Youngstown Sheet and Tube Company. I realize it doesn't really roll off the tongue. We just call it Youngstown, or the Steel Seizures case. At this time in the United States military was involved in a war in Korea. And separately from that, there was a threat of a major strike by steel workers in the United States nationwide. The steel workers and the owners of the steel mills were unable to reach a compromise on improved wage and working conditions for the workers, and the strike was looming. President Truman was concerned that a steelworkers strike would disrupt the supply chain of steel to the United States military, placing American military at risk during this war in Korea. So he issued an executive order basically nationalizing, taking over the steel mills. This was, in our country, an unprecedented move, and the steel mill owners quickly went to court and took it up to the United States Supreme Court. And in a series of many decisions, I think at least 6 separate opinions, the Supreme Court told President Truman no, that this executive order went beyond the boundaries of the president's power and was unconstitutional and unenforceable. The answer here was no. Can you do this? But the devil is in the details, as we say, and the justices struggled to decide what framework should they use to answer this question. Over time, we now look to one of those opinions, not the principal opinion, actually. We look to a concurrence by Justice Robert Jackson for analyzing questions that arise today about the scope of presidential power. Justice Jackson is one of my favorite justices. He was the last American Supreme Court justice who did not, in fact, graduate from law school, but became a lawyer as an apprentice. He's one of the most beautiful writers on the Supreme Court. We really care about that. And you can see that genius, that pragmatism, and that genius in his concurring opinion, which is now, again, this is the framework for analyzing questions of presidential power under our Constitution, at least until the Supreme Court changes the framework, which could happen. So, of course, Justice Jackson was a brilliant advocate, and he knew that lawyers in the United States only can deal with 3 things. So he made 3 buckets of analysis, because that's how American lawyers think, in a rule of 3. And he explained basically that in our system of limited powers and distribution of power among the branches of government, when the president acts with the authorization or approval of Congress, the president is acting at the zenith of his power. That in that situation, he is the most likely to be able to constitutionally act using an executive order or other tool. That's bucket 1. Bucket 3 is the opposite. When the president acts in contravention of the express or implied will of Congress, the president is at his weakest. And in general, when the president does that, his actions will be held unconstitutional. And indeed, in the steel seizures case, the court basically all agreed on the facts that what the president was doing was not supported by Congress. The problem with Justice Jackson's beautiful framework is bucket 2. Even at the time, Justice Jackson recognized that there's things that can happen where it's actually not at all clear what role Congress has, or whether Congress approves or doesn't approve. And Justice Jackson called this the zone of twilight of constitutional authority. So because we have this messy middle in bucket 2, the twilight zone, and am I the only one who's hearing the theme song of the television show right now? Do, 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 do. Because of this bucket 2, this framework helps us to begin to answer questions, but it does not, it's not prescriptive. It doesn't provide answers. And one of our points today is that because Congress is weak, and because the Supreme Court supports the president, this framework is leaning more toward giving the president more power than he typically has in our often divided and contentious government. So what does this mean? It means that the boundaries of presidential power aren't fixed for us. They're flexible, they're permeable. And in our current environment, when you look at the structure of the government and the voices, the most powerful voices of our federal government, you have to think that within that framework, a lot of power is currently being delegated to our executive, to Donald Trump.
And I think part of it, and again, that is a little bit beyond the purview also of what we are doing today. But obviously, we are all aware of the fact that the Supreme Court right now has become more of a political body than it used to be, or maybe used to be perceived to be in the past. When we are looking at President Donald Trump's executive orders, this is what we are seeing. We are seeing, as I said earlier, he has used more executive orders in his first few days than any president before, and he's really governing through them. When you look at that, what has he tried to target? He's targeted certainly higher education, and again, that's why we're here today. We're going to discuss that more in depth. He's targeting DEI, any kind of diversity, equity, and inclusion type initiative, really trying to protect the right of minorities. He has gone after that. He has tried to specifically just fight and punish law firms in particular, but also universities that have gone against him. One of the law firms where I used to practice, where Arif used to practice as well, has specifically been targeted immediately after Trump took power by basically trying to prevent him from having, trying to prevent the firm from having government contracts. He's gone after climate change, any energy policy also, and we've all heard that. He has gone after any kind of immigration and immigrants coming in. There's a lot of cases that are active right now. In Los Angeles, you may have heard that recently, there's actually masked, armed, unidentified individuals that will go to lots where immigrants are waiting, that will go to places where it is well known that there are Hispanic individuals or Latinos individuals. They go after anyone who speaks with a Spanish accent. They grab them, even if they might be American citizens, they put them in a van and then they try to deport them. So that's some of the things that have happened recently. And he has also gone after international relations, as we know, with the Paris Climate Change Agreement and all of those things. As a side note, that doesn't, again, completely belong to this, but it was really interesting that when President Zelensky met Trump earlier this week, Zelensky made sure to say, "Thank you, Mr. President," at least 15 times. People counted, and that seemed to go over really well. So that's an interesting glimpse into the psychology of the president. In terms of the executive, higher education, specifically executive order, we talked about the bucket of executive orders that he is targeting. We are going to go through those in order, more or less. So Professor Porter is really going to talk about the anti-DEI executive orders. I am going to focus on the retractation of federal grant funding, the freezing of the budgets that you talked about when we started. And then we're going to talk about the revocation of future student visas, the targeting of specific institutions, including, of course, law schools.
So in 2023, the United States Supreme Court issued a highly controversial opinion holding that affirmative action, which is to say efforts by institutions of higher education to make sure that their student bodies actively reflected the diversity of the nation, their communities, and the world, was unconstitutional. The Supreme Court had prior to that held for decades that affirmative action by educational institutions was in fact constitutional under the Equal Protection Clause. So this was a quick shift of policy by the Supreme Court. But even in that opinion, as controversial as it was, the Supreme Court made sure to clarify that actually people's lived experience, which could, for example, include their experience of persecution on the basis of their religion or their race or their gender, could continue to be an important and valuable part of universities' admissions policies. So we have this decision that comes out in 2023 that prohibits, in a fairly narrow and technical way, the use, for example, of race or gender or other identifiable characteristics in the admissions process. And notably, what is not counted in there is, for example, the very strong tradition that American private institutions have of admitting the children of their alumni, notwithstanding their inferior, sometimes, qualifications. President Trump has essentially taken this decision and used it as a sword to attack all efforts to discuss racial equality in workplaces, in schools, in curriculum. his mission, he says, is to remove woke ideology from higher education, but also, for example, from our national museums. So some of his very first executive orders and his second term of office, issued on January 20th, targeted the concept of diversity, equity, and inclusion. And I just want to pause and note for a moment the stark contrast between the Emancipation Proclamation of President Lincoln, President Truman's executive order desegregating our national military, and President Obama's effort to provide a path to a productive life to the dreamers, children of immigrants to our country, on the one hand, and the executive order that's seeking to attack all consideration of things like equity and inclusion, on the other hand. In tone, it's aggressive. It's a legally aggressive move. It's also, in terms of our culture and norms, a radical and deeply concerning shift.
And you notice, again, we were talking earlier about the way it is worded. You can see that it's what we called, wolf whistles, defending women from gender ideology extremism. You can see that the language ending illegal discrimination and restoring merit-based opportunity, as if immigration is the opposite of merit-based opportunities, right? So he's really trying to really pass very strong political messages through that.
And I just want to note that this messaging, this non-legal language, is effective in the sense that people read them, they look at the titles, they talk about it. So even if ultimately many of these executive orders are held unconstitutional, even by the Supreme Court, in the meanwhile, President Trump has cast a massive chill on educational institutions and workplaces all over the country. And to some extent, it will be very hard to undo that balance. So he's that damage, excuse me. So as a communication tool, these are already kind of fully armed weapons that are being used. So what's actually happening inside universities? Universities are now, I think, fairly frantically evaluating long-standing policies that actually encourage diversity, equity, inclusion, both in terms of recruitment of faculty, not necessarily admissions, but certainly recruitment of students, in giving of scholarships, and also just in having, for example, lunchtime talks or employee trainings. And they're trying to figure out and do independent, basically, analyses of, on the one hand, where do they think this is all going to shake out legally if it goes to the Supreme Court, on the one hand, and separately from that, what's their risk tolerance? How much grief and pain and lost funding are they willing to risk in order to defend these ideas? Because of course, when you lose funding as an institution, what does that lost funding prevent you from doing? It prevents you from helping support children and students from underprivileged backgrounds, right? So at some level, there's all these trade-offs, and each institution is in its own world trying to deal with them. So you can see, right, that if you look in the United States, you'll see that different institutions, different educational institutions, are making different decisions in this environment, and it's partly based on their leadership, on their student body, and whether they're a specific target of Trump or they think they can get under the radar screen, but it's also partly based on their resources and the support of their boards of trustees. Most recently, or actually maybe it's last month now, President Trump specifically targeted law schools. He believes that law schools are basically indoctrinating students into liberal ideologies, and he believes that the American Association of Law Schools, which accredits, or the Law School Association Council, Accreditation Council, which accredits law schools, is encouraging by its rules and forcing law schools to teach progressive values. So in addition to going after undergraduate and research institutions, the president is also in specific targeting legal education and the accreditation of law schools, the body that accredits law schools, in an effort to force these organizations to more conservative faculty, and to change to remove any element of equity in the consideration of accreditation standards.
And before going on to the federal funding freezes, one last idea that occurs to me is that we really are in a 1984 George Orwell type of world, because I remember, I don't know if you remember, Liz, when we received a letter from in the law school from the Department of Justice that started out, we long have wanted to protect individuals against discrimination. And then the next sentence went on to say, so it is time to end discrimination against Caucasian white people. And that was incredibly jarring, because the language initially made me feel like, oh, what's happening here? And then you just went back to basically using the tool of protection to now become a weapon of aggression. In terms of the funding freezes, I can go somewhat fast on this, and I will do so. But some of the things you all have heard about that, and you likely have heard in the news about a lot of Ivy League institutions. We will focus a little bit. Professor Porter will discuss Harvard in more depth. You might have heard about Duke. You may have heard about other institutions, but it's not just the Ivy League institutions that are being targeted. There are actually 4,000 grants that are being considered being terminated right now, and they concern about 600 universities and colleges around the United States. So we are in a dire situation when it comes to the federal funding freezes. In terms of the data of the amount, the Trump administration says that basically it is looking at a lot of grants. The value of the grants are between 6 to 8 billions. And given what has already been used, we are looking in total of cuts around 3.3 and 3.7 billion dollars. So it is really quite breathtaking. My own daughter was actually looking at doctoral programs at the University of Washington. And when you look at certain PhD programs, it now says we are no longer accepting applicants, or we're not accepting applicants for 2026. So we are suffering. We'll talk about that a little bit more. Of course, public institutions are very much targeted, more so than private institutions, but it is targeted across the board. And the institutions that are unfortunately suffering the most are historically Black colleges and universities. They have been very affected with, as indicated in the slides, more than 2/3 of our land grant universities, nearly half of all of the historically Black universities and college targeted for funding termination, which again just kind of fits in this scheme of attacking really minorities. Overall, when you take a look at what we are looking in terms of who is affected, as I said, it's really doubly public institutions, about 2.1 billion in total, compared with private institutions, approximately 1.2 billion. Still, we are talking about billions of dollars here. We are not talking about much, about very small amounts. When you're looking, and this slide is a little bit difficult to read, but when you're looking at whether it is measured by the Treasury Department, or whether it is measured by Doge, which was Elon Musk's brainchild, you can see the total amount of the grants for various types of colleges, and you can see how much is remaining in those grants that have been targeted for termination. Basically, almost 50%, right? There's not a lot that had been, I mean, there's some that had been spent, but it is being targeted. And the conclusion to this really for all of us, and that is extremely disheartening, is that it hurts the economy. It hurts American competitiveness. It hurts American image abroad. I have nephews who are in Europe right now and who say to me, I wanted to come and do my PhD in the United States, and I'm not doing that. I'm doing it in Sweden. I'm doing it in Germany. I'm doing it elsewhere because I am too scared of what is happening. the University of Washington, which is a public institution, a top recipient of grants. Again, we had several meetings, several, discussions where in particular, things such as medical research have been targeted, just, engineering, all of these advances that have made the institution the powerful institution that it is. So it is very sad and heartbreaking. If you look at the effect on an individual student, it's about, almost $300 per student. And this is just so difficult because there are students who will just have to forego education because of what is happening right now.
And we just wanted to note that people who work at the university, like us, who've been working at the university for a few decades as scientists at the university, are basically just retiring early. So in addition to the catastrophic funding, sorry, it's coming in and out, we're losing a lot of deep institutional knowledge. Not necessarily really even tenured faculty, because they do have some salary protections with tenure, but career research scientists who've been dedicating their lives to looking for cures for Parkinson's disease or cancer, and who now, they're basically in their late 50s, and where else are they going to work? Every institution is similarly affected. So what we're going to see is a wave of retirement, transmitting knowledge to the next generation of scientists. And it's so hard now to capture that lost information and knowledge. Finally, we just want to note that President Trump and his supporters had a specific strategy, which was to take down some big victims fast. So some of the institutions that were targeted appear to have been targeted so that the Trump administration could make an example of them quickly and other institutions would fall in line. And one of the things that's most disheartening about this, of many disheartening things, is that some of those institutions, in fact, did fall in line and made deals, essentially, which, they thought maybe saved their science, saved their students, saved their faculty members, but at the cost of the Constitution. And right now in the country, I think if you talk to people in the United States, many people think of Harvard as kind of a arrogant, stuck-up institution. And many people now feel like Harvard, which decided ultimately to fight the Trump administration, is in a way the last hope, because if somebody as well-resourced and both in money and intelligence and in lawyers cannot win, then we're all lost. Finally, and I'm sure you're aware of this, there's a huge uncertainty about the ability of international students to get visas. So for example, at Harvard, percent of the student body is international. So the president specifically planned to revoke all existing international visas and prevent Harvard from having any other international students. And actually, many students at the University of Washington, current students, had their visas revoked over the last spring, and only quick lawsuits saved those students from being basically grabbed off of campus and deported. And again, courts are generally seeking to stop this, but it's much easier for courts legally to prevent existing visas from being revoked than it is to regulate the incoming visa approval process for prospective students. So now what we have are people who are planning to study in the United States. They have visas, but when they arrive at an airport, their visas may not be upheld and their social media may be scrutinized. And then we have many, many students from across the world who would like to come to study in the United States and simply will not, because the risks are so high. And parents would be sending their kids off to a potentially hostile foreign place where they might risk losing the cost and the value of their education or detention.
Yes.
At worst. And we actually don't yet know. We won't really know until the fall what the impact of this international visa scare is. But the long-term result is that it's very possible that America will lose its preeminence in university education as a result of all of these many simultaneous assaults.
And it might seem, something that you're thinking from like up above to at an intellectual level, but we did have training on campus on what to do if you have an immigration officer coming to your classroom. And I guarantee you that that puts a little bit of a different mind frame in the way you handle that.
So, as I said before, several universities and several law firms have opted to settle with the Trump administration, even though, for example, in the case of the law firms, no court has even thought about sustaining the constitutionality of executive orders targeting individual law firms. But there are currently law firms spending millions of dollars a year doing free work for Donald Trump and the Donald Trump administration. And one of the problems I think that will be ongoing for universities like Columbia that settled, like Brown that settled, is that Donald Trump has not proven himself to be an honest partner in contracts and agreements. In a way, now they're locked in an ongoing relationship where the demands may be constantly shifting. Finally, there's a question of pure academic control, academic freedom. And we just wanted to note how attorneys representing the Trump administration in court have explained their logic to judges. They've just said, well, we give funding, the funding has to align with our priorities. We don't like these priorities, therefore we withdraw the funding. They would like to take this not as a governmental investment in education, but merely describe it as a contract like any other contract that's contingent upon their ongoing satisfaction. The Trump administration has in court argued that this is a punishment for anti-Semitic activity by pro-Palestinian protesters on campus, but the targeted funds are unrelated to the protests, unrelated to the students, and unrelated to any formal investigation that has happened about the way universities have handled this. So there's not, one of the problems with analyzing this from a legal perspective is that the government is just making things up. And it's very hard to analyze. There's not time for a trial, for evidence, for the things that usually makes our justice system effective. Instead, it's sort of a battle of spin, and that makes it difficult for even lawyers, but certainly non-lawyer citizens of the United States or other countries to look from the outside and actually understand what's going on.
And one of the issues and a certain lack of outrage, unfortunately, is that while they are stating that this is about anti-Semitism, there are several individuals in the Trump administration with close links to anti-Semitic groups. There are people who have been photographed with Nazi uniforms, and yet they are saying that they are going after this. So again, Orwellian world, really.
And as of now, just to give you a sense of scale, there are more than 1 million international students studying in the United States. This is affecting a large portion of the student population in our country.
So to finish this off, a few thoughts that we wanted to just have you stay with us, that obviously higher education has been under threat from various angles, right? We are being attacked in every single way in our ability to attract and enroll, in our funding, in our budget, which is where it really hurts. You know this, operating institutions, in the ability to make our own hiring decision, frankly, in our ability to say what we want to say about racism, about gender protection. And there's a loss, as Professor Porter indicated, there is a loss of scientists, of brain. There's a brain exit that likely is taking place in the best institutions in the United States.
And as we conclude, we wanted to kind of just note, who's going to solve these problems? And unfortunately, it's not going to be us. It's you people, students here, students in the United States, rising generations of new lawyers and activists. You will be the ones who have to confront this, basically re-strengthen the rule of law and a kind of international dialogue about equity, peace, and advancement. And maybe I should apologize on behalf of my generation because we're not leaving things in an easy position for all of you. But that is why you are here.
Thank you so much.
Thank you, Professor Butler and Professor Porter for the thought-provoking presentations. My quick response, like we have something in common, but I don't really explain what's happening in US. In this presentation, we will compare experience about how a lot of practice is like, threatening our academic freedom in Indonesia. Please, Bu Susi.
Thank you very much, Professor Elizabeth and Professor Miral. Thank you for your insight presentation. And as Pak Bilal said, that we are very surprised here that happened in United States, a country who always claim as a democratic country and uphold the human rights principle. Okay, and now it's a very brief presentation. How about in Indonesia? I think that the relation between government and university, like we have to answer the question how to deal with the thorny problem between government and universities. And the problem that's reflected the power relation between government and universities. And there are two aspects that should be considered. The first one is so how to deal with the thorny problem between government and universities and power relation, and it reflects the power relation between government and university. And there are two aspects that should be considered. The first one is the perspective of the organizational structure. For example, in Indonesia, how about the relation between the central government and Ministry of Higher Education, Research and Technology, as well as the legislative body that we have, the Education Commission. And from the second perspective, that is the perspective of the power boundary, as you mentioned before, such as in US, there is the express power, the implied powers, and then the prohibiting powers. And whereas in Indonesia, for example, how the court decision will affect the relation between government and universities, because a couple months ago, the Constitutional Court handed down its decision, stipulate that free of charge, so the education is free of charge, and then as a result, the Ministry of Primary and Secondary Education try to think how to implement the court decision, because in Indonesia, education is a mandatory spending. According to the 1945 Constitution, should be at the minimum 20% of the annual budget that allocated for education. Oops, sorry. So the interesting thing why there is like a thorny relation between government and university, because educational practice is actually such as a spectrum of education. One end is composed of rights, individual and freedom, but the other end is composed of power, state, and order. And after this, how to ensure that this spectrum will enhance the academic autonomy, whether the other end that composed of power, state, and order much stronger rather than another end that is the individual and rights, individual and freedom. What you say or what you explain about the current situation in US, it seems for me that The second N, much stronger, that is the power, state, and order, rather than the second spectrum, that is rights, individual, and freedom. Oops, sorry. So what is the academic autonomy? I just quote some of why. Sebelum ini. Still the academic autonomy. Okay, I quote some of the meaning of the academic autonomy. That is, academic autonomy is the freedom of institution to run its own affairs without direction or influence from any level of government. And then academic autonomy will allow university to determine how to develop and design strategies in order to achieve their goals and objectives. Another meaning of the academic autonomy, actually, the academic autonomy is an umbrella concept that denoting the autonomy or self-governance of a university by virtue of its academic role and status. And sometimes academic autonomy is taken in a narrower sense. It then refers to the specific freedom to design and define academic programs and curricula and to select all categories of students. That's the meaning of academic autonomy in a narrow sense. And now I will move to this is the overview. Okay, next slide. Yeah, this is the overview of the Indonesian education system. Actually, there are 4 levels of education: primary, junior secondary, and senior secondary, and higher education. The first 2 levels constitute basic education, as the term is used in the Indonesian context. And state education institutions dominate the education system, particularly at primary and junior secondary levels. However, the private sector also plays significant role. But responsibility for managing the education system has changed significantly over time. For example, under the new order, the regime that ruled Indonesia from 1965 to 1998, education was highly centralized because Indonesia is a unitary state. So unlike US, the federal state, Indonesia is a unitary state, and education was in hand in central government. And the Ministry of Education and Culture had the primary responsibility for managing all levels of the education system, with a number of other central government ministry and agencies also playing significant role. And the most important of these was the Ministry of Religious Affairs. Again, this is unlike in the US. We have the religious education here in Indonesia, and mostly the religious school was under the responsibility of the Ministry of Religious Affairs. In 2001, the central government transferred authority over education policy and management to district level government in line with decentralization. So the junior and the senior secondary school was transferred to the local government. However, the higher education still in the hand of the central government. And the Directorate General of Higher Education within the Ministry of Education and Culture continued to coordinate, supervise, and direct all state and private higher education, while the Ministry of Religious Affairs maintained close oversight of the network religious higher education as matters related to religious education. Next slide, please. In October 2014, then the newly elected President Joko Widodo removed the Directorate General of Higher Education from Ministry of Education and Culture and merged it with the Ministry of Research and Technology, creating a new Ministry for Research, Technology, and Higher Education. The Ministry of Education and Culture was left with responsibility for managing primary, junior secondary, and senior secondary education. And the Ministry of Religious Affairs retained responsibility for religious school as well. Yeah. Next slide. But under the President Prabowo administration, the ministry have been divided into three. So now we have three ministries. The first one is the Ministry of Primary and Secondary Education, Ministry of Higher Education, Research and Technology, and Ministry of Culture. And each of the ministry have their own deputy minister. So you can imagine this is the first time in Indonesia that we have more than 50 deputy minister. And that's what we call among the scholar in the constitutional, like the bloated cabinet. Yeah. Because we have a very fat cabinet and very fat coalition. However, Ministry of Religious Affairs is still responsible to manage religious school. And the major reason behind the establishment of the bloated cabinet, because the president and vice president have to accommodate a number of the significant actors that give benefit during their running as the presidential and vice presidential candidate. So you know that like the political accommodation, okay, you already give me a credit, then I will give you a position. And unfortunately, yesterday, one of the deputy ministry of the labor was arrested by the anti-corruption because of like a bribery or something like that. So can you imagine that this is only 10 months? Within 10 months, then one of the deputy minister was arrested. Yeah, and this, he could become a minister again because of at the time his name is what we call the nickname is Pak Noel. Then Pak Noel gave the benefit to become what we call the Prabowo mania. So he fully support to Prabowo presidential candidate. So, what type of relation between government and university? The involvement in the autonomy of university are reflected in the three aspects: the personal employment power of the university level, then the personal appointment and removal power of the management level, and the personal appointment and removal power of the decision-making level. And another involvement in the autonomy of university financial management, mainly manifested in four aspects: the budget, income, expenditure, and asset management rights. And the involvement in the academic autonomy of university is mainly manifested in three aspects: the academic freedom, academic performance, and academic trend of university. Then the involvement of administrative autonomy is mainly manifested in four aspects: university strategic decision-making, enrollment management, and student management, and other affairs. How about state university in Indonesia? So I highlight the state university in Indonesia. According to regulation, there are three status of the state university in Indonesia. The first one is work unit status, or what we call in Bahasa Indonesia Satker, Satuan Kerja. So totally dependent to the government. Then the financial management directly controlled by the government. The second type is public service agency status, partially dependent to the government, but have more financial autonomy, but still under the government supervision. And this is the third status of the state university in Indonesia, that this legal entity status supposed to be fully independent of the government and supposed to be fully autonomous in managing their internal affairs. And what we are quite worried in the current situation, that it seems to me that the government give a more status to the state university in Indonesia as a legal entity status. Because in the government mind or in the government thinking, once the university has become the legal entity, then the government could then slowly attract from his the state responsibility for financing budget and etc. And for the legal entity status university, the university cannot have ask or require to the central government to have their lecture with the status of civil service. This is one of the biggest challenge, because you know that mostly state university in Indonesia has a quite high number of students. The student body is quite high, but we have a limited number of the lecture. So for the state university with the legal entity status, they have to carry out the to make the examination to attract people to become the lecturer, and it's totally funding by the university. It is very hard for the university. So it seems that the government try to give more status to this state university. And in my opinion, this is one way that the government want to minimize their responsibility in managing higher education in Indonesia. So the intervention, what is the reward and what is the punishment? Unlike in US, as you mentioned before, that the President Trump issued some kind of the executive order. That's rarely happen in Indonesia. What kind of legal instrument that used by the government? It seems to me that the government used ministerial regulation rather than the executive order, such as here, like the ministry regulation regarding the changes, about the appointment and the dissolution of the head or the leader of the university, of the state university. And Minister of Higher Education, Science and Technology hold 35% of the voting rights from the total number of voters present in the election of rector or chancellor. So you know that 35% is a quite significant number, and it is one of the sign that the academic autonomy in Indonesia is in dangers, because the government can use their power, 35 voters, in order to appoint the preferred rector. And in 2021, the rector of Universitas Indonesia appointed as the commissioner in Bank Rakyat Indonesia, a state-owned enterprise. And I think this is, I don't know, maybe only happened currently during Jokowi and followed by Prabowo, that the academic then give an additional job as a commissioner of the state-owned company. we don't know what is the major behind that appointment, but our assumption is to make the university to become more softer to the government rather than give their strong critic. Again, here also happened at the University of Indonesia that the President Joko Widodo revised the statute of Universitas Indonesia in order to allow the rector to be appointed as a commissioner in a state-owned enterprises. And what happened at the time, because I have information from Professor Har Kristuti. Professor Har Kristuti is a leader of the professor board in University of Indonesia. Before the statute, what we call the statuta. Statuta is look like the like constitution of the university, and it has a form of government regulation or peraturan pemerintah. So before the university changed the statuta, then the proposal to change is already discussed by the Dewan Guru Besar or the professor board. However, without telling this board, then the rector directly sent to the secretariat, state of secretariat. And again, silently, then they changed the initial draft that proposed by the professor board. So this is one of the intervention that have in Indonesia. Another intervention, again, still in a reward and punishment, such as the head of the sociology study program at University Negeri Jakarta was dismissed from his position after reporting Joko Widodo to the Corruption Eradication Commission. But now, I think this is Pak Ubed, ya, Ubaidillah Badrun. Also, the Student Council of the Faculty of Social and Political Sciences of Universitas Airlangga was suspended after creating a satirical flower arrangement addressed to President Prabowo. However, not long after this incident happened, then the new minister of education, the new minister of science, research and higher education then ranked the rector of Airlangga University asking to they not longer the student association is no longer freeze, so become an active again. That's after the minister give a ring to the rector. And now happen also the criminalization of Professor Bambang Hero and Professor Basuki Wasis for her statement regarding state losses in the teen corruption case in Indonesia. And another thing is repressive action by the police against the student demonstration increasing significantly. Just a couple of days ago, there is a student discussion in one of the university in Eastern Indonesia, and the student want to discuss about law on army. And accidentally, then the discussion then was cannot longer carried out. So you can, and people say, okay, there is someone behind this cancellation, something like that. Yeah. But apart from that threat, moving forward amid threat. And this is what I will show you about a number of 151 professors from the medicine faculty of the University of Indonesia sent a letter to the President Prabowo asking their concern about the policy that issued by the Ministry of Health. because there is a significant changes in terms of the medicine education in Indonesia according or based on the new law on health. Now, the education, the medicine education can be carried out not only in the faculty of medicine, but also can based on the hospital base. So, and the last one is that some of the students of the faculty of law at Unpad filed a procedural review petition against the law on the Indonesian National Armed Forces. And we are still waiting what the Constitutional Court will say about the procedure matters of law on armed forces. We are still wait, but we are not have a great hope, yeah, that the Constitutional Court will give his favor to the applicant. This is the end of my presentation. I made a number of significant threats, but we have to be very still optimistic in order to accompany our student, yeah, because if the lecture is pessimistic, all the lecture pessimistic, then who will accompany our student in order to reach the future better than us now? Thank you.
Thanks. Thank you, Bu Susi, for the also interesting presentations comparing our another problem in Indonesia. So we are now reaching the Q&A sessions, but we only have around 15 minutes. So I hope I can give a lot of opportunity to us for the audience, but maybe the first three audience first who want to ask questions or opinions about this topic, please raise your hands. Yopi, and then there, and then one more, if any. Yola, question. Yeah, in four, it's okay. Or yeah. Start from Yopi, please.
Okay, thank you, Pabil. I have two questions for the two professors from the Washington. So my first question is, I'm curious about the way how the courts review the test on the executive order. Is it only the formal review? I mean, is it only the review to test? Is it the president have the valid power to make the executive order, or could it be possible that the courts could consider about the human rights in deciding about the validity of the executive order or about the presidential actions, such as, oh, it is against the Bill of Rights, it is against the rights of the rights of education. So there is any possibility about that? And my second question is, there is any solidarities from all of the universities across of the U.S. or the students of the U.S. about what happens in the U.S. So I mean, like that is the national symptoms, right? So there is any solidarity attempts from the university students or from the university scholars to against or to retaliate the Trump actions. And my question to Busi is, do you have any list of reforms that Indonesia must do in the future to strengthening the Indonesian legal the Indonesian universities? So do you have any idea for reforms, or do you have any idea to repair the current conditions? Thank you, Pabil.
Oh, we asked all the questions. Oh, wow, okay.
Okay, first, thank you for the insight and all of the presentation. This was actually addressed to Professor Mirel and Elizabeth, and I apologize in advance if my English have any mispronunciation. So this was actually a hypothetical question, but how does the executive power from the United States president have much binding power. So let's say that it is different based on the constitution of each nation. But let's say that in the United States, the Federational Constitutional Republic holds a shared divide between the central government and its provincial states or constituent state that have significant authority of their own. And is that right? And then what if the federation central government issued an executive order to implement a measure, but the measure that was implemented by the provincial government or the constituent state failed and caused a breach? Does that responsibility for that breach is falls into the federal government, to the provincial government, or is shared between both entities? Thank you.
Good afternoon, professors. My name is Viola from Indonesia, Jentera School of Law. I have a question for Professor Porter and Professor Butler. Sorry. In terms of legal education, especially in your class, Professor, how do you echo and how do you encourage the student to be critical of the undemocratic movement of the executive power towards the higher education recently? Thank you.
Good afternoon, professors. Thank you for the insightful presentation. I would like to ask about the international visa from student. Is there any concrete steps or concrete measures concluded by the government or even by the university itself? As currently me and a couple of my friends, we're currently competing in the international moot court that will be held in Boston later in October. So there is some certain fear among us that we can be held in the airport or maybe during the competition, or maybe we can come back to Indonesia. So there are certain fears. So maybe the question is, there are some concrete measures or there are some concrete steps that are concluded by the government or Mercedes itself regarding this issue. Thank you.
Yes, we've kept track of it.
Okay, we're going to try to begin at the beginning, and I apologize if we lose something as we go through all of these questions sequentially. But I think the answer to your first question, it's my understanding, and I apologize if I'm incorrect in this, that the Constitutional Court of Indonesia basically says this law is valid or this law is invalid. That's not actually the way the United States Supreme Court works. We don't have a separate Supreme Court and Constitutional Court. We have one court system that does all civil and criminal law, and it can review decisions pertaining to federal law coming out of federal courts as well as state courts. And our 9 justices will write opinions that can be either very narrow and technical or can be quite sweeping, depending on the topic and depending on the actual nature of the justices. And over time, they seem to have more and more words. So for example, in Youngstown that I showed you, the decision that we consider to be the most important decision in analyzing executive power was not even the primary decision. It was a concurring decision, a separate decision written by one justice, basically saying, well, this is how I think about it. And what that means is that when courts receive these executive orders and analyze them, some of them actually will make substantive rulings on constitutional rights that are important. Some of the rulings are pretty technical and procedural. So a ruling came down recently about funding that said, oh, you filed it in the wrong court. You had to file this in the Court of Federal Claims, not this court over here. Not very satisfying if you're a litigant. The Supreme Court just decided that, I believe, yesterday. So in answer to your question, it's possible for courts to say more. What's happening now is that trial courts, the lower courts, are outraged at these executive orders and are saying quite a lot. Appellate courts are more cautious, Supreme Court more cautious still, and the Trump administration has basically intimated that it will really only give credence to Supreme Court decisions, which leaves us in a pretty awkward decision, an awkward place. That's my answer to the first question, I think.
Yes, and to add to that also that the Trump court, because a lot of the lower courts are the ones that actually are saying, no, you can't do that. When it moves up all the way to the Supreme Court is often left with procedural issues. And so they don't really decide on the substance, but by saying that there has been some procedural issue, they allow things to keep on going on. As for the second question, which was solidarity between students, there definitely is. And there's a lot of lawsuits right now that are happening. There's also a lot of organizations in the United States. For example, the American Civil Liberties Union, they are filing cases left and right to really try to protect a lot of the rights. Again, this is beyond just education, but for example, you might have heard about a lot of targeting for individuals who are transgender, or a lot of targeting for individuals who do not necessarily fit in the traditional gender categories. And there is just a lot of pushback by a lot of organizations, and a lot of our students at the law school are very much wanting to become lawyers because they want to defend the rule of law. So what Professor Susie was saying is exactly right. And what Professor had said, the solidarity exists. Students want to get their education to move there. I think the third question was a question about federalism.
Yeah, actually, the third question was about the relationship between the federal government and the state governments. It's a really excellent question, and you could take a whole course on this question at law school, and you may very well do so if you were studying in the United States. We don't have, and I was interested in looking at how education is regulated in Indonesia, where you have a more unitary system, and where therefore the federal government formally has a big role in education. In our system, I'm going to say two things that go in different directions. In our system, we actually give most educational control to states and localities, which means that it's very difficult to make a generalization about the American educational system because it's a patchwork of 50 different systems, more than 50 different systems. And sometimes you say that's inefficient. Some systems are very poor, but usually it's very difficult to actually exert federal control over their systems because we have a tradition of local control and because it's just kind of complicated. However, under the Constitution, if there's a valid federal law, that federal law will displace inconsistent state law. So we have two things true at once. One, strong local control of education and educational institutions. And two, federal law wins if there's a battle. And and three, which we didn't realize, we're all so dependent on money. Local control, federal law preempts, we all need funding. These three things are a very toxic stew right now, and the result of it is unclear.
The fourth question, and we're going to go through them as we remember, but I also remember that there was a question for Professor Susie. So if that works, we'll answer those, and then we'll let Professor Susie answer the question that was addressed to her as well. Is that okay? Okay. So I remember that the fourth question was, how do we encourage students to be critical? Maybe that is a question actually for the three of us. I think that the way I would encourage my students to be critical is just really to learn the tools that you need to learn as lawyers. So in a way, my answer is not very sexy. Do your homework, read the cases, really understand the substance of what is going on. Do not rely on ChatGPT or on nonsense that
Not
gives
TikTok.
you...
No TikTok, please.
Exactly.
No TikTok.
Just no canned stuff. Just make sure that you just learn to think like a lawyer, because the more you learn to think like a lawyer, the more you are able to examine the documents. There is a joke in the United States that say that lawyers, they are, when you play a society game, lawyers, they are the only ones who have read the rules at the top of the box. So read the rules at the top of the box so you can play the game and you can win the game.
I would only add to that. I would only add that in this time of an enormous amount of stress for you as students now, for you entering the profession, for all of us, I think it's also really important to have fun. So in addition to studying hard, and I absolutely believe in really reading the rules, I think it's important to make a conscious effort to do things with your friends and family and get out and do things that aren't just studying, so that you can have an inner resilience and joy that can take you through this hard time.
How do you encourage your students, by the way?
Yeah, please, your turn, Bu Susi.
Thank you. The question, if I'm not mistaken, how to improve the quality of the higher education in Indonesia? I think the improvement can be carried out to based on two perspective or based on two reason or two aspect. The first one is the aspect from the government. So I think that the government should avoid what I call the politicization, because this is very important I think maybe not only in Indonesia but also throughout the world. It is the government should make the self-restraint to always intervene or to always give the political influence to the education institution in this country. And the second thing, the second aspect is from the internal aspect, from the university itself. Because why from the university itself is also important. Here in Indonesia, in particular the state university, so once a rector to be appointed, then the rector have to sign what we call the what is the index kinerja utama, the primary index of performance. Okay, so like the contract with the minister. So this is what I call the politicization of education. I think that if once the government recognize that there is the academic autonomy, there is a academic freedom, there is a university autonomy, then the government should comply with that principle. Okay, and the leader, the academic leader, is completely different with the bureaucratic leader and the political leader. So the academic wants everyone who appointed to become a leader in the educational institution should ask themselves whether I have a capability to become the academic leader. Because in Indonesia, the leader of the university or the leader of the faculty have a very huge task, but mostly in administrative tasks. And this one of the consequence of this, the academic leader then will do not have enough time to expand the leader quality that he or she should equip with the nature of the academic institution. And another thing, in addition to the leader, so how the university student should act themselves. I agree with Professor Miral and Professor Elizabeth. You have to be critically. You have to develop your critical thinking, because once you're able to develop your critical thinking, then you will be able also to solve the problem. Not always the big problem, but also the problem that attach to the society. Perhaps I can share with you. This is one of the interesting vision and mission that developed by Universitas Parahyangan. So the vision of the Faculty of Law of Universitas Parahyangan does not even say about the internationally recognized. But they prefer that they want to become the academic community who able to produce the alumni who have a very sensitive with the people need. And one of the mission, I think one of the interesting mission is that how to bring the local wisdom internationally and how to equip the student the feeling that can help the marginal society. I think it is very important for university in Indonesia not always to think about international recognize, because the international recognition will come automatically once the university or once the faculty improve their quality of learning, quality of research, and the quality of community service. Thank you.
I think
Yeah, how we encourage the student to be critical. Again, not only supported by the lecture, yeah, but also by, again, the leader of the university. So the leader of the university should provide a safety environment for the student that to become a critical thinking. And again, it is very important now in Indonesia how to ensure the student to become brave enough to say what they think about the current situation. Because you know that one of the student, the faculty of law from the Islamic University in Indonesia, they receive intimidation when they applied for the procedural review of law on armed forces. Now, this is again, but I think that don't worry about become a critical person, because it is very important for you to become a very critical person in order to have you provide contribution not only for the society, but also for the development of science.
very true. And yeah, I think there was like one last question also to say, though I do want to say that the fact that we're here today and talking about this proves that there's a lot of bravery and strength in the Indonesian institution, and that everybody really wants to do what is best for each of our countries. So that is in itself, I think, very encouraging. I think that the last question was any measures, any concrete measures that are taken, that can be taken to help international students who are thinking about coming to the United States and thinking about studying in the United States. You know, that's a bit of a difficult question because in terms of concrete measures, we certainly, once you are in the US, for all of those students who were under threat of having their visas revoked, all of the universities helped, provided counsel, provided guidance, made sure that things were taken into account. There's a lot of pro bono lawyers who right now are willing to help out. But the question is more what Professor Porter had evoked. What if you have your ticket, you have your visa, you come in, and for some reason they take a look at your phone, they see something that they don't like, or they just stop you there at the border. Unfortunately, I think that those are things to consider.
But it sounds from the question as if several of you are planning to go for the Vice Moot Court to Boston or something like that, a moot court competition. And I think just
You
to,
could be fine.
I think there's a lot less scrutiny of people coming to the United States. There's still millions of people entering the United States from all over the world every day for a variety of business, cultural, educational reasons, and to visit their family. I just want to recognize the uncertainty and the apprehension as being real. And yet I think in the vast majority of this throngs of people are through the visa process successfully and uneventfully entering the United States.
Yeah, and what I would say is just make sure that all of your documents are in perfect order. Make sure that you have everything just done properly, that everything is verified, that you have all of the right authorization, and you should be fine. Just a word of warning that they gave me because I am actually a naturalized American citizen. I was not born American, but switch off your phone. There's likely nothing bad on my phone, but switch off your phone anyway. Do not have your phone in front of you so that they can actually turn the phone towards you. Then it opens up and then they can look at things. So I would just switch off my phone, keep it in my pocket. You don't need to be watching that video when you're going through customs. So just kind of keep your phone away. Yeah.
Thank you very much for all the speakers. Please give applause for our speakers here, especially to Professor Butler and Professor Porter. Thank you for sharing your thoughts. It's very insightful talks with you, and also to Professor Susi. Thank you for always accompanying us to be defending our rights here, and also supporting the students here. Thank you very much. And this is the end of our international lecture. Thank you also for our audience to be here and participated actively. So good afternoon and see you next time.
Thanks. That was so interesting. Deep, but interesting. I know. Oh, yes. I'm sorry. Yeah.
Here in the
Do that. I think it's just for the ceremony photos, maybe.
Thank you, Pak Bilal Dewansha, for your skillfully moderating today's discussion. Also, our deepest gratitude goes to our distinguished speaker for sharing their valuable insights. There will be a little gift or a souvenirs to our distinguished speakers today, given by the Faculty of Law Universitas Pajajaran, Jentera School of Law, as well as the Constitutional Law Department, Universitas Pajajaran. First, I would like to invite Dr. Nella to present the tokens of appreciation from the Faculty of Law Universitas Pajajaran. Next, I would like to invite Dr. Arya, Chair of Jentera School of Law, or the representative. I'm sorry, Pak Arif, to also grant their tokens of appreciation. And lastly, I would like to invite Professor Susi from Constitutional Law Department, Universitas Pajajaran, to also grant our gesture of appreciation to both of our special speakers from Washington University School of Law. And now we kindly invite all of our distinguished our distinguished guests, Pak Arif, Dr. Arya, Pak May, and other lecturers to join us to the front to have a documentation session. We would also like to express our heartfelt thanks to Indonesia Jentera School of Law and the University of Washington School of Law for their trust and partnership in today's collaboration. With that, we officially close today's International Public Lecture. Thank you once again, and we look forward for seeing you at our future events. Wassalamualaikum warahmatullahi wabarakatuh.